So I'm welcoming our second panel, which includes our moderator, Professor John Efron, Professor Richard Bucksbaum, Professor Hanna Yablonka, and Professor Eric Stova. I'm going to introduce our moderator, and then Professor John Efron will introduce our panel speakers. Professor John Efron is the Koret Professor of Jewish History at the University of California, Berkeley, where he is a specialist in the cultural and social history of German Jewry. A native of Melbourne, Australia, he has a BA from Monash University and did graduate work at the Hebrew University in Jerusalem. He took his MA at NYU at New York University and earned a PhD at Columbia University. In his work, John Efron has focused on the way German Jewry attempted to reinterpret and reinvent Jewish culture in the wake of the complex encounter with modernity. His work has focused on the German Jewish engagement with science, medicine, anthropology, and anti-Semitism, and he has written on subjects such as Jewish burial, circumcision, and dietary practices, among many other topics. He's just completed a book, manuscript, on German Jewry and the allure of the Sephardic, a study of modern German Jewry's attraction to the aesthetics of medieval Sephardic Jewry, which will appear in Princeton University Press, and he has published many other books as well on German Jewry, on Jewish history, and the like, and I welcome him here to introduce the rest of our panel.
Thank you very much, and thanks once again to the first panel for starting things off in such a bright and informative manner. You know, Nuremberg, I mean, at a certain level, what we're talking about is punishment. And a number of the defendants, of course, got the death penalty. Some didn't. And for some of them, there perhaps was a punishment worse than death, if that's at all imaginable. I was in graduate school with the granddaughter of one of the defendants, von Papon. Now, von Papon, if being a blithering idiot was a crime, he would have gotten the death penalty. On January the 30th, 1933, he came out with one of history's most insane statements. As Hitler was installed, he said, "Jetzt wir haben ihn eingerahmt." Now we've got him boxed into a corner. That wasn't the case. So anyway, his granddaughter did a PhD in Jewish history at Columbia University. Another one of the defendants, or another one who wasn't there, who escaped because he was killed in 1942, but would have been there, but he was succeeded by Albert Speer, who, as you know, got 20 years at Nuremberg. And that was Fritz Todt. And Todt was responsible for building the autobahns. Todt's granddaughter is one of the world's leading authorities on Yiddish literature. So there are, perhaps for some of these people, fates worse than death. And history has an interesting way of being ironic in that respect. Anyway, so it's my pleasure now to as we were watching the film last night, probably like some of you, I was sitting there as, 5 minutes rolled into 10 minutes, and 10 into 15, and 15 into 20, saying, where are the Jews? Because they hadn't been mentioned yet. And it's probably around 40, 45 minutes in that they are mentioned. But we're going to find out a little more about where they were, and perhaps even why it took so long for them to be mentioned at the trial. It gives me great pleasure to introduce our first speaker, and that is Dick Bucksbaum, who is, as you all know, in the Faculty of Law here and has been since 1961. His own work is in the fields of corporation law and comparative and international and economic law. And as Ken mentioned last night, Dick was one of the 5 defense counsel in the criminal proceedings against the 773 members of the free speech movement from 1964 to 1967, and represented various campus organizations and individuals in cases arising out of the Vietnam War protests. But more immediate and more germane to this is that as a legal officer at the US Army's European headquarters in Heidelberg from 1954 to 1957, he had, among other assignments, the duty to review and make recommendations concerning applications or clemency or early release by lower-level participants in war crimes, what we today would call violations of international humanitarian legal principles. And he also served as a liaison to the German judiciary in the context of NATO's Status of Forces Agreement that went into effect with the Federal Republics gaining full sovereignty in 1955. So Dick is an eyewitness to events, and certainly to legal proceedings that occurred in the post-war period. So it gives me great pleasure to give the microphone over to Dick Bucksbaum.
Well, I have to begin at a totally other location, but thank you, John, for mentioning the FSM, because I was reminded by Professor Maris that he was one of our defendants in that trial. I hope you don't mind the violation of privacy here. I don't know even where you are right now, but, oh, okay. But is it okay?
He's a free man.
That's true. The limitations have run on that particular incident, right? Well, the question of where were the Jews, for me, has to be put into a somewhat broader context, and in fact, Laurel Fletcher, in her question earlier, gave me a bit of a segue to that. Because, of course, the Nuremberg trial didn't take place in a vacuum from late 45 to mid 46. At the same time, the Western Allies, which at that time still included Yugoslavia and even Czechoslovakia, were meeting in order to carve up the reparations they were going to demand from the German defeated German Reich. This led, of course, to a lot of issues concerning for whom those reparations were going, material reparations were going to go, and that was one of the places where, for example, a certain degree of Jewish participation occurred. Chaim Weizmann, who had been briefed, of course, on this already from the 30s on by people like Nehemiah Robinson and so forth, asked for appearance at the conference, which led in January 46 to the reparations treaty, if you can call it that, and therefore demanded something for the stateless victims of the Germans, but separately for the Jewish victims, because even at that time there were, of course, non-Jewish victims. And so there was a kind of a small internecine skirmish between the two groups of victims, but the point for me is that there was participation to some degree, although the amounts eventually set aside for this particular purpose were derisory and known as such even at the time. Another context, of course, came up very soon thereafter, when after the recreation of the Federal Republic of Germany in 1949, the issue immediately came up of how to settle Germany's obligations to the West, which were at that time not the war obligations, but the handling of the pre-war bonds that were in default to the private sector creditors. These were often the reparations bonds that substituted for the reparations obligations after World War I, and the repayment of the Allies' support of Germany through aid and support in the immediate post-war years, and so on. But at the same time, and parallel track, the questions of compensation, not directly to Jews, but to the State of Israel for its costs in accepting the large part of the surviving members of the Shoah, and to the newly formed Conference on Material Jewish Claims Against Germany, the Claims Conference for the diaspora Jews. All of that, of course, was taking place at the same time or very closely to the end of the Nuremberg trials. They were taking place, in fact, even into the Nuremberg trials, but not of the ones you've been looking at, but rather of the second and third and fourth echelons of those trials. Professor Ephron mentioned this personal note. that as late as 1954, when I was in the European headquarters in Heidelberg, one of my first assignments indeed was to review petitions from these people, all of whom, the petitions we were involved with were all of the classic international humanitarian law violations, that is to say, violations of the laws of war, but at the lower levels, the local constable who had pitchforked an parachuting airman to death rather than taking him to the local constabulary, that kind of but those trials were still going on even after 1949 to some extent. So there is a kind of a context here which puts the particular issues that we're facing into a little broader area. Now, my job here, as I see it, is to go a little bit into the weeds. That is, we've had very excellent reviews already by the first panel of the issues of the difference between the crimes against humanity charges, the crime of aggressive war charge, and the humanitarian charge, the crimes committed in the course of the war. And that obviously segues, as indeed the first panel did, into the issue of, quote, where were the Jews in that context? So let me go a little bit into this. I'm going to start by reviewing the actual counts of the indictment. Right? The first count, and this is the one that caused the greatest trouble among the tribunal framers, was the count of conspiracy. Right? This is, of course, an Anglo-American invention. The civilian system doesn't know it. The French were upset by the notion that such a thing could be put in. The Russians, well, it varies. Smith claims without evidence that they were envious that they hadn't thought of it first. That, I think, is a little bit of a problem. They certainly had enough conspiracy charges of a different sort during the show trials in the 30s. In any event, the first charge was conspiracy, and of course, the first problem with it already was, when did that conspiracy begin? Right? Are you going to start it in 1933? Are you going to start it in 1923 with the Putsch effort and Mein Kampf and so on? Are you going to start it with the occupation of the Rhineland in 1935? Where are you going to start the conspiracy to wage, and now come all three of these things, to wage aggressive war, right? To commit humanitarian law violations, though they weren't phrased that way, but commit violations of the laws of war, and to commit these problems of what we would today call human rights law, genocide, and so forth. So one problem was that the allegation of conspiracy swallowed up almost the three substantive counts. If you actually go into the way the trial was framed, and some of that showed up in Sandra Schulberg's way of framing, or the original film framing, when they always went back to the backdrop and then said, now comes count two, and so forth. But if you actually look at them, you can see how little of that had to do with our panel's concern, and how much had to do, in fact, with the interstate relations of the time. The conspiracy count used the Nazi Party, the National Socialist Workers' Party, as the central core of the common plan. It provided 5 categories of subcounts within the count of conspiracy. They were basically framed in terms, especially as to the definition of their common objectives, it was basically framed in terms of geopolitics. Right? The abrogation of the Treaty of Versailles, the reacquisition of lost territories, read, for example, Rhineland, right, and some to the east, and then finally the acquisition of European territories in the east that the Germans claimed were necessary for their Lebensraum, for, and which were in fact, according to the allegations, the Germans claimed were occupied by ethnic Germans, and so forth. Right? So it was a kind of a geopolitical specific. The second category tried to do something about the indoctrination through cultural concepts, but satisfied itself by simply speaking of the fact that they propagated the concept of the master race and the concept of the Führer principle of total leadership in strict hierarchical terms. Now, while we've heard already this morning that the problems that beset both German Jews and German political opponents in the 30s, before the war, became problematic in terms of where they would fit in the trial. In fact, the most developed category of the conspiracy count was that of the acquiring and consolidation of political control within Germany, that is, control of the state machinery, destruction of the trade unions, a subversion of the educational system, a subversion of the influence of Christian churches, the persecution of pacifist, especially religiously based pacifist bodies. This is the one time where there is a thin statement of also persecution of the Jews as a religion under the ground of the master race. And indeed, this is the time when individuals specific to that, Streicher, the Stürmer editor, Rosenberg, the ideologue, Ley, the lawman, are used even at the level of evidentiary support. Okay, I want to make two side points at this point. The indictment suggests that the conspiracy to wage aggressive war was already in that pre-planning stage, including the physical annihilation of the Jews. Now, this is became at the trial a very difficult issue. Obviously, during the 30s, it suited the party to have the kind of horrible stuff that the Stürmer, Streicher's publication, which I used to read as an 8-year-old, was preaching. Right? But the purpose at the time, I think one has to say that, was to try to drive the German Jews out of Germany. Emigration was the aim. The issues of what would happen to the Jews of the East, right, of course, began to loom larger and larger and larger as preparations for war began to come in. But if we're speaking of the first period, right, emigration was the aim, and in a way, the emigration was not prohibited for Jews until late in 1941, after the breach of the Molotov-Ribbentrop agreement, right? So this is something that, of course, also then came up in the trial as a matter of saying, how can you bring the conspiracy to annihilate the Jews back that far, right? That's the first point, right? The second is the very concept of conspiracy itself. As I mentioned briefly, it's an Anglo-American invention, right? Bradley Smith says, and I quote this, "The questions of ex post facto prosecution," which we, after the war, had a lot of arguments about, of course, and which caused quite a few of the Jewish emigre scholars to refuse to participate in the Nuremberg trials. I mean, my late colleague, Stefan Riesenfeld, was asked to be part of the team, and he said, no, this is too much of an ex post facto trial. And that was a rather common point among a number of them, right? Nonetheless, that question, and a separate question about why would we prosecute and declare criminal the organizations of the Nazi party, the Russians said, that's nonsense, we've abolished them. We're just, what's the point of having a trial about that? These were issues, true, but they were not nearly as serious as the eruption over the concept of conspiracy. And of course, as I've just finished saying, one of the reasons for that is that the concept lent itself to big debates about its reach in time, backwards in time, its aims at any particular set of times, and so forth. So these were things that troubled the court and that, in a sense, show up in the allegations themselves. The last two of the conspiracy claims were relatively straightforward. The mobilization for aggressive war, which of course was a kind of new crime, and the last is trivial, right? The preparation for aggressive war basically had to do with the Rhineland, with the Sudetenland, with the Bohemia-Moravia issues, and that was, in a sense, the last of this conspiracy account. But what happened as a result is that when you get the conspiracy count to go to the other areas, that is crimes in the war, and especially then, of course, the crimes that we would today call genocide, they had almost nothing. It was like the breath ran out of the indictment. The conspiracy counts themselves have very, very little on that, and the actual counts then also have little, and especially even when we get into crimes against humanity, how little, even there, they have focused on Jews. And I want to go to that point first. However, there still are a couple of things about the fact that this was an interstate issue and not one focused on the victims as such that bears pointing out. The framing of the charges relating to the invasion of Poland was a delicate matter, obviously, right? The Molotov-Ribbentrop Agreement, which was still nominally secret in 1945, gave the USSR unopposed entry into the eastern part, which they took advantage of 2 weeks after the German invasion, right? Now, the justifications for the Soviet incursion sound a little like the justifications for Hitler's annexation of Austria. Unrest in the eastern part of Poland, a call for order, a call for the troops to come in and establish order, and so on. And that became a little bit of a trouble during the evidentiary part of the proceedings. More interesting is that the German Defense Council for, I forget now which, it could have been Ribbentrop, I'm not sure, tried to introduce that secret non-aggression pact between the Germans and the Soviets. Rudenko, the Soviet prosecutor, objected violently to that, claiming there was no such thing, at which point the German Defense Council demanded that Molotov be called as a witness. Now, Nimitz was called as a witness and came. The idea that Molotov would be called as a witness was, of course, a grandstand play, if you want to put it that way. And the court finessed it very nicely and said, well, before we call him as a witness, we have to have a copy of the non-aggression agreement. And, of course, we need an English or a Russian language version. And with that little gimmick, they stepped off that landmine, and came back to the main case, right? The indictment also framed, as I said, the annexation of Austria, right, as an invasion. And of course, that was the wartime decision taken to treat Austria as a victim rather than as an aggressor for geopolitical reasons. That was just the follow-up on that. Now, interestingly, the indictment never spoke of the minor Axis members who joined later, that is to say Hungary, Romania, and Bulgaria, not a word about the co-belligerent Finland. And so this is the largest part of the indictment. I'm speaking now both of the conspiracy count as it anticipates these substantive counts and the substantive counts themselves, because this was practically a duplication. So we get now to the two issues that count for us. Crimes against peace, as it was called, which would now be the humanitarian, and the war crimes, a little different, and crimes against humanity. They are barely mentioned in the conspiracy count. They occupy 3 short paragraphs of a 41-page indictment and state only conclusions of law. The crimes against peace, again, are not detailed and occupy less than a page. They simply incorporate by reference some of the conspiracy. So we get to the big one, right? The detailed allegations under crimes against humanity and war crimes of the types of violations. Now, what do we get here? We get a few suggestions of Jewish victims, but the categories of violations suggest a different context. Of course, murder and ill treatment of civilian populations in occupied territories. But when you go to the details that are given, they are usually not the Jewish victims, but simply the Polish and other victims, the resistance fighters and so on. Deportation for slave labor, murder and ill treatment of POWs, taking a very large part of the time, exaction of collective penalties, wanton destruction of towns without justification, Lidice, Oradour, and so forth. Conscription of civilian labor, forced oath of allegiance, and Germanization of the occupied territories. That's basically the Watagau of the Western Poland. Right? The only one which comes up where there's a detailed illustration that turns to the Jews is, of course, in the ill treatment of civilian populations in occupied territories. Here is, as was mentioned already earlier, the first mention of the phrase genocide, not that it survived into the judgment, as was already pointed out, but the phrasing is worth it. Quote, "They conducted deliberate and systematic genocide, viz. The extermination of racial and national groups, particularly of Jews, Poles, Gypsies, and others. But then the particulars are grouped by areas of occupation, beginning with details about France." So let me turn to the one area where and do I have 5 minutes for this, or what's the story? You can take 10. Oh, all right, I'll speak more slowly. Let me turn to the one area where you would expect and get to some degree some reference to the victims as such. And that is, of course, when it goes to what the indictment itself calls the, quote, Eastern countries, unquote. Even there, however, a great amount of detail is provided by geography, down to individual towns. And for the Soviet Union alone, the massacres in 18 cities are described, and I should say described in pretty horrific and graphic detail. And now, especially in the region of the Pale of Settlement, right, this would have been an issue where you speak about the Jews. And there, of course, the massacres involved largely Jews, but the emphasis in the indictment is still on the general civilian population. I'll quote you 2 or 3. In Novgorod, many thousands of Soviet citizens were killed by shooting, starvation, and torture. In Minsk, tens of thousands of citizens, Grajdan, were similarly killed. In Dnipropetrovsk, near the Transport Institute, they shot or threw alive into a great ravine 11,000 women, old men, and children, unquote. Only for one of the 18 regions is it specific. In the Kamenets-Podolsk region, 31,000 Jews were shot and exterminated, including 13,000 persons brought there from Hungary. That is the only reference in the entire indictment to this question that we're faced with. Now, the state-centered nature, even of this set of particulars under the war crimes indictment, is especially evident because of its heavy, heavy concentration on plunder. Right? Page after page of the indictment is taken up with the statistics of the plunder. France, removal of raw materials. Each specific type is specified and by what type of material, quantified at francs 185 billion. Plundering of private enterprise property, quantified at 257 billion, and so on. Looting of and destruction of works of art and cultural, including religious edifices, are specified mainly for the Soviet Union. And they were, of course, very egregious there. So now let's get to crimes against humanity as such. Right? How does the Jewish population come to the fore there? The indictment contains only 2 categories. And one of them, and this is something that was taken up this morning, had to do basically with the persecution, repression, and extermination of German political opponents or those thought to be such. Dachau. Right? But that specification says German political opponents, right, in it. Right? Now, of course, Jews were, in fact, even, let's say, a minority of those at Dachau, as we know, but the extermination there of them was of a particular high level, right? It moves on then to the category of persecution, which is our core, on political, racial, and religious grounds. Takes up 1 page, right? It mentions in 1/2 sentence the deportation of German Jews for extermination, and then provides 5 examples of localized mass murders in the occupied part of the eastern countries. It mentions the mobile gassing wagons there, but the indictment itself does not go into specifics about Auschwitz or the large gas chambers, although as you saw from the film yesterday, and as we know from the evidence, which I now turn to, right, there was, of course, some of that. Now, what can one say about the evidence? The principal efforts of the defense counsel were to challenge participation or knowledge of a particular defendant concerning a given event. Right? Therefore, most of the evidence which was presented by the prosecution, which was documentary, right, was not challenged. Right? Whenever relevant, the introduced document might concern a Jewish person or group, but the documentation as such was put on record at the trial with essentially no witness testimony except for its laying the foundation to introduce it. Let me give you an example here. The report made, this was a document, of course, under this, a report made to Goebbels' Ministry for Propaganda in August of 1944 concerning the strenuous efforts of the new German authorities in Hungary in the post-Horthy regime, right, to, quote, solve the Jewish problem in Hungary, right? A quotation suffices, quote, this document says, it goes without saying that after the 19th of March, the German office in Hungary undertook everything possible to eliminate the Jewish element as quickly and completely as possible. The report, this is the German Nazi report, complains of the more liberal Hungarian definition of privileged Jews, of the most diverse and grotesque efforts, quotation, of Hungarian authorities to take account of the increasingly serious warnings of retribution coming from the Allies, right, and urges more pressure on these officers by the German side. But that's about it for any of the details of the allegation when you consider that 500,000 Hungarian Jews, slightly more, in a very short period of 2 months, right, were deported, and 400,000, well, I think it was 800,000 and 400,000 died. I'm losing the figures, I have them, but that's my point. Now, let's ask about what happened at the trial. Visual documentation came. There were some films we saw a couple yesterday, right? There was a very little bit of individual witness testimony concerning these particular exterminations and persecutions, right? 3 of the 45 volumes of the trial contain witness statements, but of course usually not in the form of presence at the trial, but in the form of previously taken statements, not cross-examined and so forth, right? Now, I can't say I have found everything, and I'm not going to claim that, but I found only 2 examples of victim witnesses testifying to the concentration and extermination camp activities. And one of those concerned Dachau and focused on the medical experimentation there, horribly stated, right? But of course it applied to across the board as to who was in Dachau. And the second, in terms of witness testimony by a victim, similar evidence from Camp Dora, right? Neither, of course, focused specifically on the Jews, right? And it was at Dachau mainly Russian and Polish prisoners of war and French and Dutch civilian prisoners who were shown in the trial as having had this. The role of witness testimony was that of the exculpatory witnesses presented by the defense counsel, right? 95% at least of the witness testimony that's contained in these volumes was of this type. And most of the rest of the trial transcript consists of arguments of all counsel. In the case of the prosecutors, arguments based on documentary evidence with very little reference to other, except sometimes to the films. In the case of defense counsel, of course, much argument on the ex post facto question, and most of the argument going to exculpate or mitigate the role of the defendants, based again on the defense documentation. I want to close by referring back to something Professor Maurer said, that it was a good thing that Himmler, Hitler, and Goebbels were not present. The one German, all of the defendants spoke, right? They were basically giving long, long statements of exculpation, lack of knowledge, and so forth, led by the defense counsel. The cross-examination was fairly successful in some cases. When Kaltenbrunner claimed he'd never been at Mauthausen, you have that scene in the film yesterday, the actual cross, catches him on that. But one of the most fascinating, in a rather macabre way, is to read Goering. It was like a fencing story. His testimony takes about 250 pages. He spoke for days. I say days, 2 days, I think it was, right? The cross-examination was a shambles, right? He was very cold, was not trying to exculpate himself in particular, but was trying to be very specific as to when and at what times what happened, and therefore mainly arguing about the question of the depth of the conspiracy and its beginning, right? It was indeed, as a case where the prosecution could not crack the one witness who could be said to have been left at the very, very highest level of decision making. Right? The impression you get from the trial, if you dig into the weeds of it as testimony, right, is an enormous amount of sludge, if I can put it that way, right? The long interpolations, the long discussions of the meaning of the war, the meaning of it for later, and so forth. When you think of it as a trial in the weeds, as I tend to do if I've been myself a trial counsel, it's a uniquely, I would say, unsatisfying experience. The question whether there should have been a night of the long knives, comes up a few times, and you begin to think that that might have been a better way to get out of the whole thing and go on. It's an odd thing to say. Although my late and much respected German colleague Gerhard Kegel, who suffered a lot during the war because he was a confessional faith in the Protestant religion, said to me once, way back, that it was like the pound of flesh. It was too interwoven with the body of the Germans, from the worst perpetrators down to the rest, and you could not do it. He said you had to simply stomach it and wait for the slow release of generational change to get over this. So while I'm speaking there a little bit off the sense of the trial, it is what happened after I would say after 1960, really, that brings the story back to equilibrium. The trial itself, with all due respect to the question of how it phrased itself, leaves an impression, if you just keep reading in it, of frustration. Thanks.
Thank you very much.
I know, but I'm going to.
Thank you very much, Dick. I was reminded as you were talking, as a German Jewish historian, I was reminded when you were talking about being 8 and reading Der Stürmer about two Jews who meet each other in Berlin in 1936, and one is reading the Jewish newspaper and the other one is reading Der Stürmer. And the one who has the Jewish newspaper under his arm asks the other one, "Why are you reading Der Stürmer?" somewhat outraged. And he says, "Well, when you read the Jewish newspaper, you read about our persecution, you read about the fact that today we can't go to swimming pools, and you read about the fact that today we've lost our jobs and the world is coming to an end. But if I read Der Stürmer, we own all the banks, we control culture, we have all the power in the world, everything looks pretty good." So maybe that's why. Anyway, at the very end of your talk, you mentioned 1960, which is a perfect segue, of course, to Hanna Yablonka, who teaches in the Department of Jewish History at the Hebrew University and is one of Israel's leading scholars of the Holocaust. Her area of specialty, in particular, is Czech and Hungarian Jewry, but also the life of survivors in Israel after they arrived there. And of course, she is, I think without any doubt, the leading scholar of the Eichmann Trial. And it is about the Eichmann Trial that she is going to speak to us today. And the title is The Eichmann Trial, Was It the Jewish Nuremberg? So please join me in welcoming Hanna Yablonka.
Good morning. Thank you for inviting me over here. I have one deficiency in comparison to the other speakers. My English is not native, so I have to think about the language when I speak, so bear patience with me. And that is why I'm more cling to my written paper, which is, of course, coming from a different background, which is the Eichmann Trial, but it has a question, which is, was it the Jewish Nuremberg? And it relates to the questions that have been rising up many times this morning and also yesterday, where were the Jews at the Eichmann Trial? And it will partially try to tackle that question. Amidst, and Andre, thank you. I could not study before the lecture how to move the pictures here because the system is different. Amidst the huge excitement drawn by the Eichmann's capture by Israel, the New York Times interviewed Ben-Gurion, the Israel's prime minister, on the significance of the upcoming trial. He replied, Ben-Gurion, I quote, "This will be the Nuremberg of the Jewish people," end of quote. What did he mean? He did not say, and the New York Times did not ask. One can find 3 different voices shaping the meaning of that statement. The first voice was that of Ben-Gurion, the Israeli prime minister, speaking to the Israelis. As Kissinger said once, Israel does not have foreign policy, but also only internal policy. This was a par excellence Zionist nationalistic declaration whose subtext was this: only after the creation of a sovereign Jewish state can the Jews judge in court those who had harmed them. The second voice, that of Ben-Gurion as the leader of all the Jews, speaking to the diaspora. As much as the 4 allies who were prosecuted in the International Tribunal at Nuremberg represented the international community, so does Israel represent the Jewish people in the historical account left open after the Shoah. The third voice was Israel and Ben-Gurion as the self-ordained authorized spokesman and power of attorney of the 6 million, and their memory, most of whom, to be sure, were not Zionists prior to the Second World War. By this, the trial became also the fulfillment of the basic biblical decree of an eye for an eye, namely justice, and yes, also revenge. But was the Eichmann trial indeed the Jewish Nuremberg? The bottom line of my talk is that these 2 intensively media-covered trials bore almost no resemblance. Following this, I will refer to the general framework within which those trials were conducted, as well as to 3 different sets of arguments: the historical argument, the judicial argument, and the epistemological argument. The Nuremberg trial can be dealt with in the general framework of what Otto Kirchenheimer defined as victor's trial. The victorious allies set to judge in front of the whole world the defeated remaining leaders of Nazi Germany. But can the Eichmann trial be considered as a victor's trial? Barely so. The Jewish people of the post-war era were all but victorious after losing the core of their national body. Moreover, there exists an outstanding difference in the way the end of the war is conveyed in the national memory of, say, the French, the British, the Americans, with that of the survivors, most of whom describe, and I've read thousands of testimonies, the days of the end of the war as actually the saddest and most agonized days of their lives. But beyond that framework lay the historical, judicial, and epistemological differences. From the historical perspective, the Eichmann trial was everything different from Nuremberg in narrative as well as in its time frame. The Nuremberg team, led by the Americans, spoke mostly to public opinion back home, explaining why we joined the war, or as it is more commonly referred to, what we fought for. The issue at hand was the Second World War and Germany's conspiracy to launch an aggressive war against the countries of Europe. The period discussed were mostly the years 1939 to 1945. The Jewish story in this context was dealt with as yet another manifestation of the atrocities performed by the Germans in the countries they occupied. Last but not least, documents dominated the core evidence. I shall return to this issue in the epistemological analysis. On the other hand, the Eichmann trial was telling the Shoah, while almost completely ignoring the context of Second World War. The story was told much alongside the lines of the stories conveyed by the survivors after the end of the war to their fellow listeners. For them, the relevant opening dates were those when their cities in the cities where they lived were taken by the Germans, and Liberation Day, by that I do not mean May 8th, but rather various dates marking the slow process of Germany's withdrawal from occupied territories. The dates range from February 1944 to May of 1945, a very different time frame from the one commonly accepted for World War II at Nuremberg. The Eichmann trial conveyed the accepted Israeli paradigm of the Shoah starting January 1933, which is Hitler's rise to power, and ending ultimately, but not exclusively, in May of 1945, which was the end of World War II. The Jewish plight was told as essentially different from other civil atrocities performed by the Germans. It was a significant deviation from evil as it was understood until then in human history. At the center of the trial stood the perception about the uniqueness of the Shoah and the existence of the Jewish state, which enabled the Jews for the first time in history to judge those who harmed them. These historical differences, as such, were strongly supported by the very different judicial aspect of the two trials. A short while before the end of the war, when the issue of post-war trials was discussed by the Allies, it led to the modification of three accounts, which were mentioned many times this morning: crimes against peace, war crimes, and a new judicial category no one really understood, let alone knew how to use: crimes against humanity. Indeed, most of the Nuremberg defendants were convicted for war crimes. Only 2 Nazi criminals were convicted solely for the Jewish Holocaust and for crimes against humanity. These were Baldur von Schirach, the commander of the Hitler Jugend, Hitler's youth group. He was convicted based on crimes against humanity for poisoning the minds of German youth, and was among the few not to be sentenced to death, but rather to 20 years in prison. The other was Julius Streicher, who was also mentioned this morning, the founder and editor of the famous, or yet infamous, Der Stürmer, who was sentenced to death. Both are a rather strange pick, given the essence and scope of the crime, especially so Streicher, who was executed. Streicher, who is considered, by the way, by many historians as insane, was not a member of the military, was not part of planning the Holocaust, the invasion of Poland, or the Soviet invasion. Yet, his role in inciting the extermination of Jews was significant enough in the prosecutor's eyes and judgment to include him in the indictment. This decision, by the way, is still debated until today because of its implications on the freedom of speech and the press. Eichmann faced a trial based on Israel's Nazi and Nazi collaborators' punishment law of 1950. It is a very unique law in Israel's law system. Its first article deals with crimes against the Jews and crimes against humanity in that order. This law is unlike any other law in Israel's criminal system. It is retroactive, as it deals with events that happened before the establishment of the state. It is exterritorial, as it deals with events that happened outside the country, even on a different continent. It allows hearsay evidence. It allows judging again on the same crime. It has no passing time limitations, and it forces, once convicted, the death penalty, which was abolished in Israel in 1954. During the Eichmann trial, the prosecution brought 110 witnesses who described in the first person their ordeals in the various European countries, ghettos and camps. In the Nuremberg trial, only a few Jewish witnesses were summoned. One of them I will represent to you at the end of my talk. Some by the Soviet team. The French team also gave way to the Jewish plight, but did so through non-Jewish witnesses. Both were countries who were actually the only ones who were under German occupation. Generally speaking, however, the Jewish issue was marginalized, although not ignored. One can see that even the Auschwitz testimony was given at Nuremberg by a French political prisoner by the name of Marie Couturier. She described the process of selection in Auschwitz as concerning the Hungarian Jews, as well as the stages of murder, and I quote, and I would like to show you. So, Andre, please, I'm sorry. I don't like to read text without showing it to you.
The video?
No, it's this.
Oh, okay.
Okay. How do you move it? So I will not call you.
So just
this.
Right?
No, but I need. Okay, that's it. What I need. Okay.
Yeah.
That's it.
They were taken. They, the Jews, were taken to a red brick building with a sign that said bath. There they were told to get undressed and given a towel before they were taken to the so-called shower room. After the people were undressed, they were taken into a room that looked like a shower room, and the capsules were thrown down into the room through a hole in the ceiling. It keeps going on and on. I just don't have the time to read all of it. But I want to draw your attention to the fact that the description is in the passive figure of speech. And it is completely in the passive figure of speech, which leaves the victims actually voiceless. The voice of the victims is not heard. Besides which, it strengthens, of course, the notion and the discourse about the Jewish passiveness during Second World War and the Shoah. Nor was the Jewish voice heard when one compares the content and words of the opening first paragraph of the indictment in the two trials. First, let me quote the opening paragraph of Jackson. May it please, I hope I'm not doing, okay. May it please your honors. Everybody sees that? Yes. The privilege of opening the first trial in history for crimes against peace of the world imposes a great responsibility. We heard that yesterday. The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. I read it quickly because of yesterday. That four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. Now I shall quote the opening paragraph of Gideon Hausner, which became in Israel a canonic text. Now, I usually, when I show this paragraph, I ask what was the Eichmann Trial about? Well, of course, the answer lays in the question, but only to a certain extent. In the place in which I stand before you, judges of Israel, to prosecute Adolf Eichmann, I stand not alone. With me at this moment in time, I am joined by 6 million prosecutors. But they are unable to rise to their feet, to point an accusing finger at the glass booth, and to cry out against the man sitting here I accuse, because their ashes have settled among the hills of Auschwitz and the fields of Treblinka, were wasted by the forests of Poland, and their graves are scattered across the length and breadth of Europe. Their blood cries out, but their voices are unheard. I shall therefore be their mouth, and I shall read in their names the terrible bill of indictment. Although the two men are aware of the fact that they are both on the road to the history books, Jackson refrains from any personal reference, This is very much in contrast to Hausner presenting himself as a representative of the 6 million with biblical references. Now, I want to show you 4 elements in this opening remark, which answers my question, what was the Eichmann trial about? It was first and foremost, of course, the trial of Adolf Eichmann. The second is, of course, it was the first manifestation, which was really, really marked during the trial, of the significance for the Jews of having a sovereign state of their own. See how many national references are here. First of all, when he speaks about judges of Israel, he goes to the ancient time of the Jews after entering Palestine after the Egyptian exodus. Now, the second thing he goes to is j'accuse, I accuse. J'accuse goes to the Dreyfus trial, which is actually the birth cradle of Zionism, because Herzl was attending that trial, and Émile Zola have been writing this essay in the newspaper, accusing the French of being anti-Semitic in their exclamations. And the third one, which is the most important that I want to show you, is, of course, I shall be their mouth. Of course, the blood crying from earth is the first story in the Bible, Cain and Abel. And I shall be their mouth goes, of course, to Aaron speaking for Moses with Pharaoh, which is the cradle of the creation of the Jewish nation, the Egyptian Exodus. Jackson spoke for all parties involved in the trial. Hausner, by comparing himself to the mission imposed on Moses and Aaron by God in Egypt, has a very specific national Jewish entity in his vision. Hausner sanctified the number 6 million. Jackson spoke very carefully of the 5.8 missing Jews, he said. This does not even touch the tone of the two prosecutors, Hausner's as that of an ancient prophet, contrasts strongly with Jackson's topic-focused law enforcement prosecution. Later on in the trial, Jackson portrayed the crimes against the Jews. Again, they have no voice and no perspective. Their plight was actually the secret weapon of Germany's war machinery. In his words, anti-Semitism was promoted to devise and embitter the democratic peoples and so soften their resistance to the Nazi aggression. In his summation, it's also symptomatic. He says, determination to destroy the Jews was a binding force which at all times cemented the elements of this conspiracy. On many internal policies, there were differences among the defendants, but there is not one of them who has not echoed the rallying cry of Nazism, Germany awake, Jewry perish. This state of affairs had a profound epistemological impact. The Western public and cultural discourse following the Nuremberg trials centered on World War II history and the victory. They were striving to return as soon as possible to normality and the process of healing. The Jewish story during Second World War was viewed merely through German documents, where German eye portrayed the Jews as passive, amorphous, anonymous crowd, the string puppets in historical event, the subject of decisions made by others. Even the Warsaw Ghetto Uprising, which is considered to be the first urban resistance in the whole of occupied Europe, was determined from General Stroop's report of the event. He, of course, saw the rebels as bandits, regardless of age and gender. The Jewish people during the Shoah were thus described as going to their deaths like sheep to the slaughterhouse, and their leaders as collaborators within the German killing apparatus, implying that some of the blame for the mass murder lies on its victims' conduct. A profound change in this reception came about the following of the Eichmann trial. Conceptually, that trial shifted the center of the discourse from the phase of the victim's guilt into the ongoing debate over the murderer's guilt. The long discussions over the yes or no banality of evil, the choice to do good or evil, and the essence and origins of evil, all of which are to this day the core issues both in research and in moral, social, and popular discourse. This is probably why Raoul Hilberg's groundbreaking The Destruction of the European Jews was published some 15 years after the Nuremberg trial, and Isaiah Trunk's pioneer book, Judenrat, was published some 17 years after the Eichmann trial. While the first based his historiography exclusively on German documents, drawing the conclusion that the Jewish functionaries, Judenrat, Kapos, Jewish militia, played a crucial part in the German death machinery, the second was listening also to the Jewish eyes, giving much more sensitive and high-definition view of Jewish leadership during the Shoah. To conclude, both trials indeed stemmed from the German defeat in World War II, but also both relied on their verdicts exclusively on written documents, but that's where the resemblance ends. The trials refer to different historical events and thus bore different conceptual outcomes. One of the basic theories in the study of the history of the Shoah is that of information, knowledge, and awareness or consciousness, meaning there exists an epistemological gap as well as a time gap between the assimilation of information into actual knowledge and from there the formation of a holistic perception. Naturally enough, the problem grows more acute the greater the distance between the event and the reservoir of known human experiences. The Holocaust was most certainly an unprecedented event, the knowledge and awareness of which required the destruction of previously accepted thought patterns. The problem of information and knowledge can be observed also in the post-war years, when the processing of the information came in on the Holocaust and the returning of it into knowledge and perception were rather slow and probably could not have been otherwise. Looking backwards, it was at the Nuremberg trial where much of the information was found and made known to the public. It was at the Eichmann trial that this information turned into actual knowledge. Personal remark. The history minister has many times proven to be a rather ruthless and ironic judge. 70 years after the Nuremberg trials and 50 years or more after the Eichmann trial, it is my understanding that the Shoah has, to a large extent, overshadowed Second World War in the public mind. Over 480 Holocaust museums, the number of visitors at the Washington Holocaust Museum, and yes, even the Iranian-instigated Holocaust caricature contest indicate the enormous long-range effect of the Eichmann trial in unveiling this epoch-changing event of the Shoah, to use Emil Fackenheim's term. Now, I would like to end with yet one witness of the trial, and that is the poet, Avraham Sutschiber. Avraham Sutschiber was defined by the New York Times as the greatest poet of the Shoah. I can argue that, but he is probably among the greatest. He testifies here on the Russian side of the testimony. He's testifying against Franz Müller, who murdered his mother and also his son. He wanted to testify in the language of his people, which was Yiddish. Of course, the Russians did not acknowledge a national language, so he testified in Russia. And that, I think, will give you one notion to the third lecture, which goes to testimony, but I just want to draw your attention to one element. This is a par excellence example of testimonies of the first decade after the war. He speaks in the first figure plural. All survivors who spoke and testified in the first 10 years after the war spoke as if for those who did not make it. Only after the Eichmann trial, we find for the first time the testimonies in the first personal figure, which made a whole big epistemological difference. And I'll call Andre my right hand. It's in English.
Avraham Sutschiber, a Jewish poet born in Lithuania, wished to give his testimony in Yiddish, but was obliged to speak Russian. Afterwards, he wrote freely of his experience in Nuremberg.
For the 2 nights before my court appearance, I did not sleep a wink. I could see my mother, naked, fleeing across the snow-covered field. The hot blood that ran from her bullet-riddled body began to run down the walls of my room and encircle me.
You must sit down if you wish.
Twice, I said that I did not wish to sit as others did. I spoke standing up, as if to recite the Kaddish for those who had died.
Please tell me, witness, where were you at the time of the German occupation?
In the city of Vilnius.
You lived in this city for a long time during the German occupation?
I lived there from the first to nearly the last day of the occupation.
You witnessed the persecution of the Jews in that city? I would like you to tell the court about this.
Когда немцы захватили моего города Вильно,
When the Germans captured my city, Vilnius, about 80,000 Jews lived there.
ловцы, это же зондеркоманда, или как евреи,
The manhunters of the Sonderkommando, or grabbers as the Jews called them,
ворвались днем и ночью,
would break into Jewish houses at any time, day or night,
вырвали отсюда
drag away the men,
мужчину, сказали взять с
instructing
собой
them to take a piece of soap and a towel,
и полотенце, и загнали их в направлении
and herd them into certain buildings near the town of Panare, about 8 kilometers from Vilnius.
откуда почти никто.
From there, hardly one returned.
Когда мы дошли до старой синагоги, этой улицы,
When we reached the old synagogue, I saw a pile of wood stacked in the shape of a pyramid.
что там лежит дров в форме пирамиды. Немец выбрал револьвер,
A German drew his revolver and told us to take off our clothes.
когда мы уже были голые, он взял спичку и
Once we were
подпалил
naked,
дров.
he lit a match and set fire to the stack of wood.
Тогда второй немец выбрал, принес с
Then another
синагоги
German brought out of the synagogue
Торы,
3 Torah scrolls,
дал нам их
gave them to us,
и сказал,
and ordered us to dance around this bonfire,
этого костра и пели
singing Russian
русские песни.
songs.
И за нами стояли эти 3 немцы,
Behind us stood the 3 Germans.
нагнали к огня.
They forced us at bayonet point toward the fire,
Мы уже били почти
laughing
без
the whole
сознания.
time.
Немцы ушли. Но я должен сказать, что массовое
When we were
истребление
almost at the point of
еврейского
collapse,
народа
they left.
начался
I must say that the mass extermination of the Jewish people in Vilnius
в Вильне,
began at the moment when District Commissioner Hans Hinks arrived,
Ханс Хинкс,
as well as the expert on Jewish matters, Murr.
Мура.
First, I want to acknowledge the presence of my class, my students in my modern Jewish history class this semester have, with only a modicum of coercion, chosen to join us today. So I thank you for being here. With Hanna's paper, we sort of entered into the dimension of some comparative history, so from Nuremberg to the Eichmann Trial, and we continue with the theme, I think, of comparison and broadening it out more widely now with Eric Stova, who is Professor of Law and Public Health here at UC Berkeley in the Law School, Faculty Director of our Human Rights Center. In the early 1990s, Professor Stova took part in conducting the first research on the social and medical consequences of landmines in Cambodia and other post-war countries. During the wars in Croatia and Bosnia, he served on several medico-legal investigations as an expert on mission to the International Criminal Tribunal for the former Yugoslavia in The Hague. He conducted a survey of mass graves throughout Rwanda for the International Criminal Tribunal in Rwanda in 1995. He's the author of A Village Destroyed, May 14th, 1999, War Crimes in Kosovo, My Neighbor, My Enemy, Justice and Community in the Aftermath of Mass Atrocity, and The Witnesses, War Crimes and the Promise of Justice in The Hague. And today he will speak to us on From Eichmann to the Present, Victim Testimony in War Crimes Trials. Professor Eric Stova.
I speak rather softly. Can you hear me? Is that good? Okay. Thank you, John. Before I begin, I'd like to just say something to Hanna about when you give future presentations, please don't apologize about your English at all. Well, what I'm going to try and do is really going to be a bit of a bridge. I'm going to bridge to the panel in the afternoon, I hope, and I'm going to bridge away from the Holocaust trials to the modern-day courts and the challenges that they've faced dealing with victim witnesses in particular. And these challenges have been immense. So what I want to do is begin with the concept that I come out of my research and my colleagues' research at the Human Rights Center, is that when we look at the courts, we're often looking at the external world in which they operate and the internal world. And what do I mean by the external world? The external world is what Sandra Schulberg captures in her documentary and the didactic nature of the Nuremberg trials. Or if you shift to the Tokyo trials, when the Tokyo trials were conceived in 1946 and began in May of 1946, they were held in the auditorium of the former War Ministry. Tokyo, of course, had been destroyed, and much of Tokyo had been destroyed, but the War Ministry was refurbished, and there were bright lights, imposing daises, there were balconies where cameramen could move. There was an attempt to really teach Japan a history lesson, and the intent was there. I'll leave it for others as to whether that stuck with the Japanese population. But moving on to Eichmann and to the trials that followed in the French trials after the Eichmann trial of about 20 years separation. And I think it's fair with the Eichmann trial to say that this was the beginning, as some have suggested, of the era of testimony, that testimony was in the trial was extremely important for many reasons. It also happened in the French trials of three defendants, or three accused, and the first was Klaus Barbie, who was the head of the Gestapo in Lyon, and as you may know, at the end of the war, he returned to Germany and became involved in politics of a sort, but he had quite a bit of interaction with Eastern Europe, with communists and so on, and he became an attractive character for the the Counterintelligence Corps, which was accompanied the Allied forces, the American forces, to carry out investigations. And he was, in 1951, there was pursuit by France to hold him accountable for the killing of, murder of one of the leading resistance fighters. And the Central Intelligence Corps put him on a rat line and sent him to Italy, same way that Joseph Mengele escaped and Adolf Eichmann escaped, to Argentina, and then he went to Bolivia, where he rose up within the military and eventually was not extradited back to France to stand trial because France didn't have an extradition agreement with Bolivia at the time. But a sort of neat, not as quite like the kidnapping in Eichmann, but a more, let's say, humane way or somewhat semi-legal way, he was brought to France and put on trial. His trial was followed by the trial in 1994 of Paul Trouvier, who operated under Barbie, and he was called the French Barbie, and he ran the paramilitary group. During his time after the war, he was hidden by the Catholic Church, so he was tried in 1994. The third trial was Maurice Papon, who was a Vichy police official in Bordeaux and actually rose up to be budget minister within the French government. Why these trials were important, and I go back to the external world, and I'll leave it to historians to tell us how profound these trials were in impacting on French public opinion. But certainly the partie civile, the victims who testified in the trial, in the Barbie trial, there were 23,000 pages of testimony. It was largely this victim witness testimony that was important for bringing out some of those taboo subjects that were not discussed in post-war France. And not only the role of Vichy collaborators, but also those hushed bystanders who some said watched from behind their curtains as we were taken away to Fort Montluc, where Barbie carried out his torture, often with his own hands. And I think it's fair to say that at least with the Barbie trial, it did become the talk of France. It was on television. It was discussed in newspapers. But also, it brought out the Holocaust deniers as well. But anyway, the point here is that there is an external world, whether it's intended or not, the trials will be discussed and they will affect those communities which may be affected by the war. Another example is Argentina and the Junta trial of 1985, which is a trial I testified in for the prosecution. It was a trial that lasted 5 months. Usually trials in Argentina before then were in camera. They were not always public. But it had an actual profound impact on military culture. There was a newspaper called Diario del Juicio that every week came out talking about the trial, and it became the best-selling newspaper in Argentina. And so its impact was there. Another trial would be with the Khmer Rouge Tribunal was the trial in 2009 of Duch, who was the head of the Tulsang prison, in which thousands of people, you went into Tulsang prison, you did not leave. There were only 12 survivors in the end. And what was important there, because it was done under the continental or French system of having partie civile testify, and partie civile are those victim witnesses who will testify, well, victims who will testify. They do not, and they did not in the Duch trial, take an oath, essentially. They're there to talk about the impact that Duch's killing machine at Tulsang, the deaths there had on their families. So in a way, it's the destruction after the destruction. And they only testified for about a week, but it had an extreme impact on the Cambodian population, largely because there was a television program that broadcast every week about the trial. And the other thing that was attempted in the Khmer Rouge Tribunal was an outreach program in which some 30,000 Cambodians came and listened to the trial. They sat peasants and professionals, but from around the country. And what was unique here was the fact that many of the children in Cambodia did not talk, or their parents did not talk about what had happened in the Khmer Rouge. So if we move to the modern day courts, and those are really three courts. The first, as mentioned earlier, were the ad hoc tribunals for Yugoslavia and Rwanda, and those are now winding up their trials. What happened with the Yugoslavia courts was a sense that these trials were taking place in the Yugoslavia court in The Hague, And in Rwanda, in Arusha, they were disconnected. They were far away from the crimes. The people in these countries were not really hearing enough about these courts. And the other. So what also arose at this time? I should start. Sorry, the International Criminal Court. The hybrid courts followed, and the hybrid courts came towards the end of the 1990s, and there was a push to say we need to take these trials into the countries themselves and integrate them into the domestic judicial system. So they would be hybrid. You would have international and domestic staff and judges, and in a sense, bring the trials home. Now, one of the things that, and I'm going to give some personal story here to highlight what I want to say later, is at the Human Rights Center, or I should say as John mentioned earlier, I had spent many years in Latin America working on exhumations of mass graves from Argentina to Chile to Guatemala, later to the former Yugoslavia, the Srebrenica massacre, to Rwanda. And in that process, I became very interested in what does this mean to the families? What does this mean to watch this process? Because the most of the work we were doing in Latin America was to identify the remains to return to the family. There really were not that many trials, except for the Junta trial at that point. And I was then later joined I had what I would call a Srebrenica moment. And at the time I was working on the Srebrenica exhumations, we were going out. These are the 8,000 men and boys who were killed after Srebrenica fell in July of 1995. We were doing the exhumations later. Well, most of us were doing this work for the families, but all of a sudden we received an order from the court, which we were working with, from the prosecutor's office, that we were taking too much time trying to identify the remains, that in fact the charges of crimes against humanity and genocide did not require that every victim in the grave be identified. And this shocked all of us because we had really been working for the families before, and now our question was, are we working for the court or are we working for the families? At the same time this was happening, or a little later, my colleague Harvey Weinstein, who is here, was also at the Human Rights Center and a psychiatrist, and he was working to try and help the families when identifications were being made with the Srebrenica massacre and others in Bosnia. How do you inform families about this? So what is important in this sense was that what we were dealing with these new courts was a different situation than what we were seeing in the Barbie trial or necessarily in the Eichmann trial. And that was that the violence was so raw. You were dealing with interethnic communities that were now still divided, and yet you were holding these trials and bringing people in to testify, particularly in The Hague and in Tanzania. And the question became, well, what's the importance here? And this is where I turn to the internal role of the courts, is when you're asking victim witnesses to come and testify in trials, what is the role? How should you support them, and how should you protect those victim witnesses? And what my colleague Harvey and I began to look at and try and find out what do we know about communities, and what do they think of tribunals or tribunal justice in post-war settings? Or how do we understand what the implications are for victim witnesses who come and testify? And what we found through our preliminary research was there's very little was known, and yet we were establishing these courts without taking these factors into consideration. So that really brings me to the question of, then we had to turn and the question of victim witnesses, try and see, was there anything in the literature that would inform us about what's happening to these people? How do they think about the process they've entered into? There is a theory in social psychology called procedural justice theory, and it began in the 1970s with social psychologists, and they did come to an understanding across the world in criminal or any type of arbitration, that people who enter into it, if they are treated in three ways, one is benevolence, the degree to which they perceive that the authorities, the courts, care about them and their experiences. The second is a sense of neutrality, the degree to which they're able to talk about their experiences in a neutral and unbiased forum, and respect, the extent to which they're treated in a professional and dignified manner. This helped us somewhat to understanding, but we were also now these were cases that were dealing with domestic criminal trials, and not trials in which you're talking about victims who've lost sometimes dozens of members of their families. They've seen their homes destroyed. So it's not really telling us about what they were really experiencing. So what we did over a period of time, looking at the external world, was to examine to do a series of studies in throughout the former Yugoslavia, Rwanda, and we would later extend that to Cambodia, to Liberia, the DRC, Congo, Central African Republic, and Uganda, was to find out what communities themselves thought about the judicial process. That's another talk. But the other aspect was looking at the victim witness testimonies, and this is what we've gathered generally, and also from other studies that have been carried out with these new courts. The first is a sense of a moral duty to testify. Those who have testified, and first of all, not everyone wants to testify, wants to go through that experience, but that there was generally among those we spoke to a moral duty to testify. There was no need to stay the hand of vengeance. That was a fantasy long past. But what people talked about was their duty not so much to me as a Serb, or me as a Tutsi, or me as a Croat, or a Bosnian Muslim, but to my family and to community. And what we also found is the longer time after people had testified, we take them through all the various steps, the more satisfied they were with actually having testified. And in some ways, we seen that this could be explained because the longer you were away from the trial, and it might have been difficult, but you realized this was really the only venue that you had where you could come and speak. The other finding that we had was really we have to dispense with this trope that exists in the activist community and, to a certain extent, the academic community, that revealing is healing, and the myth of catharsis that we project, and these medical terms, onto victim witnesses who come to testify. The witness stand is not a therapist's couch. It is a very difficult thing to go through. You will be faced with cross-examination. I remember a Croatian woman I spoke to who was very tough, and she said, you know, I was going to go and set the story straight about my husband and him being taken away. And it was reliance on a certain piece of film that would be shown. And she did very well through the prosecutor taking through questions. But when cross-examination came, she collapsed because it was so difficult for her. The other issue that comes up is the tension that we have between factual and interpretive truth. And that is, particularly in interethnic conflicts, that victim witnesses who come forward have often experienced, and I think this has always worked in many war zones, is to understand is that all violence is local and all memories are local. It is what you remember happening to you, your village, your family. And so for many witnesses, victim witnesses who come to testify, if the defendant was the mayor of the town who ordered the killings, or it was the head of the police or so on, they often knew for the prosecution they had to talk about factual truths, which is the way a trial must be conducted. But for them, they were looking for an interpretive truth. It was to look to the mayor and say, we went to high school together. Why did you allow this to happen? And so all of this sort of brings us to the need, and something that these courts were not prepared to do at the beginning. And they have gradually become better, but it's to that to find ways in which they can better support victim witnesses who come to testify. And some of these ways in which it can be done is, for example, if you're going to be dealing with a case, and give an example, in Bosnia, the rape camps, where women were taken and held in rape motels or in the camps. If you're going to go in and prosecute in those cases, do a preliminary study and understand what the psychosocial issues may be, how you're best going to protect, but do preemptive work before you go in. And I also think as we continue with these trials, we need to keep monitoring how we're treating the victim witnesses. And I'll just end there, so we'll have some time for question, with a quote from Judith Sklar, who is a legal historian, some of you may know, scholar. And she says, to show that justice has its practical and ideological limitations is not to slight it. The entire aim is rather to account for the difficulties which the morality of justice faces in a morally pluralistic world and to help it recognize its real place in it, not above the political world, but in its very midst. Thank you.
Thank you very much. Thank you to all three of you. Just before I open it up, I do want to ask a question because something from as we go along, there's sort of we go from sort of almost sort of a bloodless testimony at Nuremberg, as it were, to a far more raw testimony. And you mentioned the Croatian woman collapsing in the dock, but this happened also at Eichmann with Kazetnik. So there's that issue of moving from the passive to the we and the I as they give testimony. But I want to direct my question specifically to Hanna, because I was thinking of one other thing that I don't think happened at Nuremberg and made it very, very different. And that was the testimony, the extraordinary testimony. There were many sort of dramatic testimonies at the Eichmann trial, but one of the most amazing is the testimony of Salo Baron, where he was asked to come, and he did, speaking, one of the greatest Jewish historian of the 20th century. From Columbia University, he went to Jerusalem, and he gave a tour de force history of the Jewish people without a note. It was a pretty amazing thing, but it was in terms of setting up the whole issue of what was lost. And it also raises the whole question of, from the Zionist narrative, when the Shoah began in many respects, because he starts with the destruction of the temple in some respect. So could you speak about that? I don't know, was there a historian, any history testimony at Nuremberg by any historians?
I don't think so.
Yeah.
Michael? No, I don't think so.
So this is very different. So if you could say something about Baron, perhaps.
Okay. First, I have to say that he was not the first pick.
Yes, you're right.
And if you read,
for political reasons.
Not only for political reasons, but actually, if you read some of his historiography, he didn't think that the Jews should leave Germany because he didn't see any, and he writes it black on white, he didn't see any, which of course is not to blame. Most people did not see. And historians, we spoke today about the Orientalists. Have they predicted what's happening in the Middle East? Of course, we're not prophets. But he actually wrote that the Jews can stay calmly in Germany, and Germany is a law-abiding state, and so forth. But he came, and he actually, in his testimony, Ben-Gurion writes in his diary, he disappointed us because he did not have the Zionist paradigm in his testimony, which actually, if you read the Declaration of Independence of Israel, the only paragraph relates to the Shoah is that the Shoah has proven the right thinking of the Zionists, of the necessity of a Jewish state. Baron did not think so. Right. And so he gave a huge testimony, and I refer you to Bob Lieberler's book of the Baron's biography. But
and it's on YouTube, by the way.
Oh, is it?
You can watch it on YouTube.
Okay.
With everything else, but.
But all the historians that were suggested by the Israeli Gideon Hausner and the Israeli prosecution were not in that size of Baron as the leading leading Jewish historian, and that's why he was chosen. But there was a arsenic critique over him. Really, I use that word consciously.
But the impulse to have a historian is an important thing, irrespective of who it was.
Because, you see, that was my perception. I know it's not a judicial term to define the Eichmann trial as a historical trial, both shaping an historical view and conveying a kind of a historical event.
Yeah.
That's
Okay, so, Ron.
Yeah, watching the
Take the
film
microphone.
yesterday that I had not seen before and listening to your talk about the Eichmann trial, it brings to question one of Hannah Arendt's critiques, and I'm wondering about both trials, whether they were, in what sense were they show trials versus trials about the actual actions and guilt of the accused? I don't know the answer to that, but I wanted to know what your thoughts were. Because yesterday's film seemed very pedagogic, and anyway, that's my question.
well, both, first of all, that's my thoughts. I don't give you I'm not Moses coming down Mount Sinai. Both trials had a very serious pedagogical thought in their preparation. Gideon Hausner writes it many times, and he preached it, and he even became actually the interpreter of what the Shoah should mean to the people of Israel later on, when he became a real celebrity in our current language. Show trial is a cultural concept. It's not a judicial concept. And show trial, and I feel uneasy to speak about the Eichmann trial as a show trial. If I compare it, for instance, to the doctor's trial in Moscow in the 1950s, Eichmann received a decent defense, which was paid, by the way, by the State of Israel. But saying that, there is buts. First of all, he could not bring witnesses for his defense. Israel would not allow them to come in. I don't know if there were such witnesses in Germany of the 1960s, but Israel did not allow witnesses for the defense because they said if they come, it means they were working with Eichmann, and immediately they will put on trial. They will be put on trial. The second thing is, of course, most witnesses, the 110 witnesses which came to testify at the trial, I was still lucky because I wrote my book about the Eichmann trial in the 1990s. And I met like 28 of the witnesses. More than half of them, including Dan Michman, who is today the chief historian of Yad Vashem, whose father was testifying about the fate of the Dutch Jews. He told me my father did not hear the name of Eichmann. And he told so, the prosecution. I don't know who Eichmann was. I heard about him at the Kastner trial. So most witnesses, except very few, actually never met Eichmann, and Eichmann had nothing to do with their fate. So the aim of the trial was to a large extent listening to the voices coming from the survivors, that this is the event that should expose the scope of the story of the Shoah to the Israeli youth. They didn't want revenge. They were among the most resistant oppositioners towards the death sentence that Eichmann received. They didn't want him to die. But they wanted very much the whole scope of the story, sorry, to be told. So indeed, it was a pedagogical event, but I wouldn't call it a show trial, but rather a historical trial.
My name is Rahel Halpern. I'm a physician and I'm a member of the community. I have a question also for you, Professor Yablonka. How obviously there were thousands, many thousands of people in Israel and outside of Israel that could have testified. How were the witnesses chosen? And the second question is, why did you, in the introduction to your talk, use the term revenge? In what sense was the trial revenge?
Okay. Well, these are two big questions. I'll try to narrow my answer, okay? About the choosing of the witnesses, unlike the notion that the survivors were silent, they were not. They spoke every second. During the war, they were documenting themselves, and they created the historical committees after the war, documenting what happened to them. The Jewish people are a remembering community. And from the very beginning, what Yad Vashem did was collecting testimonies. There were almost 3,000 testimonies collected in the 1950s. Some of the witnesses came from there. The second way were witnesses recommended by Landsmannschafts. That is organizations of countries of origin, the Landsmannschaft of Poland, of Volyn, of Czechoslovakia. You know, Czechoslovakia was still existing at that time like this. So they were recommended. Some of them were celebrities, like Yitzhak Zuckerman and Tzivia Lubetkin, the leaders of the Warsaw Ghetto Uprising. The police, by the way, was very much against calling witnesses to the stand, because the police people's notion was the fact that it's 16 years after the war, and they are testifying about things that did not happen to them, that they have learned through the years, which was quite true sometimes. And basically, the objective criteria by which witnesses were elected, that they could speak and that they had an interesting story. Interesting story. So some witnesses were even discovered after the trial has begun. For instance, the father of Herschel Grynszpan, who was standing in line to go into the trial. And a newspaperman discovered him. He was the one who was responsible for Kristallnacht, so-called responsible, of course. So some of them was accident, some of them were recommended, and some of them were taken from the 3,000 witness testimonies that were already collected at Yad Vashem. Now, revenge. One of the greatest phenomena, according to my eyes, of the Jewish conduct after the Second World War is the fact that there was no revenge. Because everybody was thinking, and I read their diaries, once the war will be over, we will kill so-and-so Germans and in that numbers, and we will revenge our mothers and sisters, etc. No revenge. It is a very, by the way, educational issue, the fact that the survivors chose to rehabilitate their lives, create families instead of revenge. But the issue was always there. So one venue to canalize the energy of revenge was the Capo trials in Israel of the 1950s. These were trials that Israel conducted against Jews who were functionaries during Second World War. And it was survivors who complained against other survivors. The second is the trial. Now, why did one of the reasons the survivors did not want Eichmann to die, and I read like about 120 letters that were written to the police, is keep him alive, and every year take him out of prison, take him to the wides and lengths of Israel, show him how we are still alive, what we created. That is the biggest punishment that he can receive, to see how he failed in his final solution aim. Hundreds of letters like that from survivors. So, but Jewish revenge, basically, unlike what we know from other countries against Nazi and Nazi accomplices, is really an understatement. There was no revenge. And the Eichmann trial, in a way, was a revenge because of the fact that now we have a state, we shall put you on a trial, we shall give you a fair trial, and that is basically a kind of a satisfaction that you didn't kill us all.
trials and now, thank you, the modern trials is a concern that many of us have about the fact that the normal arc of a trial, which ends in a verdict, starts with the charge, goes through process, and ends with a verdict, is not taking place in the modern tribunals. And that what is happening is that we have, whereas Nuremberg took months and Eichmann, I think, took months, it now takes years and years and years.
No, Eichmann took more than a year.
And so the question then is the legitimacy and credibility and even the integrity of these modern reflections of Nuremberg, and whether we're just missing a step in trying to figure out how to get to a result in these trials, all of the things that are to the benefit, as you say, of witnesses, is often tied up with knowing that there is a verdict at the end, and we're not getting very many verdicts. Is there something we should be thinking about in the way we prosecute war crimes today?
Absolutely. The courts, if you look at their efficiency, a colleague of mine, Thierry Cuvier, who was here recently and had him speak in one of my classes at the law school, no one has observed the modern trials as much as he has. And he's actually calculated that if you look at the accused in many of these courts, you're talking $23 million per accused. Millions of dollars per accused. And it doesn't come down to the question of this is right or wrong or we should pursue it, but there is a real difficulty in terms of the efficiency of these courts and the allowing for more testimony to be brought forward, to have, I mean, and there has to be the fair, and we have to deal with the rights of the accused, but it's just gone too far. And I think what'll happen with the credibility of all these courts, and particularly the International Criminal Court, will be decided over the next 5 to 7 years. And if the International Criminal Court, for example, isn't able to have more speedy trials, we're already seeing a movement of those countries that supported the International Criminal Court, the Western powers, moving away from it. And then if you look at the support you want to get from those, say, emerging powers, India, China, and other countries, they're not going to support the International Criminal Court. So it's a question of efficiency. And for, I think, if you look at the International Criminal Court, in many of these courts, and I don't want to get too technical here, but they tend to be a hybrid of civil and common law. And you've created this system. For example, at the International Criminal Court, they have a category called victim participation, or victim participants. And what happens is when a case begins, if you're a victim in Eastern Congo and you sign up that you were a child soldier and it matches the charge to the accused, then you're a victim participant and you might get reparations in the end. And there are hundreds and hundreds. We're doing a study now of just over 660 victim participants around in many of the countries of the ICC. And the question is, we're creating these great expectations for these people that there will be reparations. There may not be. We may see the same sort of acquittals that are happening in Kenya with the Kenyatta trial. And so we really need to take a hard look at what we're doing with these courts. So I agree with you.
Michael.
This is a question to Hanna Yablonka, and has to do, I think this question reinforces or gives you the opportunity to reinforce your point, but here is what I want to ask. There was one person who was present in both trials as an advisor to the prosecution, and that is Jacob Robinson. So there you have Jacob Robinson in 1945-46 as a kind of lobbyist for the Institute of Jewish Affairs, which he headed in New York. And he is trying to promote the attention for the court on what happened to the Jews. And then in the Eichmann trial, there he is again, working for the Israeli Foreign Office, and he is advising them on how to proceed. Could you say something about how, my sense is that
Jacob Robinson's views shifted. I think I would add to everything that you said that Jews' views shifted between 1945-6 and 1960-61. And it's important to keep in mind that that element was there as well when you talked about knowledge and understanding. 1945, we're still in the area of knowledge, and things have changed quite radically, not just for the non-Jewish world, but for Jews themselves.
My answer to your question is a whole seminar. I'm giving a whole year. But maybe I'll concentrate on two elements. The first element, of course, goes to the fact that we are not, and I find it very hard to explain to my students, to put them in a capsule of time, to understand that what we mean about media and and paper and mass media today is non-existent in the 40s. Israel's papers, which hold today like 30 pages every day, was 4 pages at the time. They never had our correspondent in Washington. All the information came from UP and Reuters, except, by the way, at the Eichmann Trial. And what they heard about the Shoah, and of course the Shoah was under a very severe secrecy, the final solution. What they heard about the Shoah was what the first survivors who came to Palestine told them. Now, somebody who came from the Vilna ghetto, what could he tell? He didn't know about the final solution. He knew what happened to him. That corresponds to what you said. It was Rushka Korczak who came December 1944, and she told what happened to the Vilna ghetto. Now, she could tell only what she's been through. She didn't know the scope of the story. Now, she knew because there were some emissaries going from one ghetto to the other, life-threatening task, of course. So she knew there was a Warsaw Ghetto uprising, but she never knew the details of it. This is the basic line where stereotypes are being born. And since the prevalent sentiment that was among the Jewish population of Palestine, and the survivors as well, was the guilt feeling. How come I survived when my mother and sister and nephews all perished? And the same with the Jewish population of Palestine. How we lived our petty daily life when our parents, because the Jewish population in Palestine was very young, when our parents were murdered. Because this was the prevalent sentiment, and because it was on the verge of the state, which was also a very competing experience. Finally, after 2,000 years, there is a chance of a Jewish state. Which experience overshadows the other, the Shoah or the coming state? It's a very confusing time, and it's a very stormy time. So at the first, I have to say, the first period, the two elements of the discourse were this victim's guilt. How can we explain the fact that 6 million people were murdered this way? It is because they did not understand what was in store for them. And the second thing is that their leadership failed. Leadership meaning Capo, Judenrat, militia, Jewish militia, etc. And this was echoed in the stories of the survivors. The term they went to the like sheep to the slaughterhouse, it was imported to Palestine by Abba Kovner. So it shifted during the 1950s. I say that by the late of the 1950s, to a large extent, the state of Israel became a mundane fact. People were no longer excited about it. It's like, there is a state, okay. And in this context, the Eichmann Trial happened, when the state lost some of its glory. The listening in the 10 years between the Sinai campaign and the Six-Day War, which were Israel's golden years, very, very secured, the German money kept coming in, So the economy was flourishing. These years, the listening in this context was very different. And suddenly there was the story in all its scope. So the discourse changed tremendously from the victim's guilt to the murderer's guilt. And the first person talk gave way to the, instead of speaking generally about the 6 million, suddenly the Israeli audience understood that the Shoah belonged to these 500,000 survivors who immigrated no less than to the 6 million. They were no longer perceived only as immigrants, but as a bridge to bridge the dying diaspora with the Israeli public, which obviously ended up in effects that are still here today.
Okay, with that, we're going to take a break now and return at 2:30. But before we just do that, I want to thank the three wonderful papers and a really exciting session. So thank you very, very much.
Great.